So something very exciting is happening in 757 days. Any guesses?
The presidential election?
No, Trevor, that's in 973 days? All right, so if you have guessed, like Dr. Chad did, I am sure, that it is the 231st anniversary of the House of Representatives holding its first quorum and electing its first speaker, you would be right. Or that it is Justice Samuel Alito's 70th birthday. Don't worry, Sam, they didn't forget. You would also be right. But I am personally most excited about National Census Day. Yes, April 1st, 2020 is the official kickoff of the decennial census. And because it's so important, I will give you a minute to mark it down in your calendars. I'll wait, mark it down. All right. So the census is important because it measures the exact extent of migration within the United States. And this is very valuable for state and national governments so that they can plan and allocate resources for public services like schools, transportation, and healthcare. But I care the most about the census because it triggers another decennial event, the 2022 congressional redistricting. Redistricting, or redrawing the boundaries between state and federal legislative districts, sounds benign enough. People move in or out of your state, and you need to reevaluate how to carve up your state's legislative districts in order to account for those changes. But a process that may have originated as a way to accommodate our growing nation has turned into a political prize. And this is going to challenge principles of fair democratic processes and voters' rights. So how does redistricting come to challenge these principles? I'd like to start with a simple explanation inspired by a districting game that was designed by Christopher Walker using Smudge, who, as guessing by the coos, you know is the best and most perfect dog, also my dog, and her mortal enemy, Poppy the dog. It just so happens that Smudge likes blue, and Poppy likes red. So Smudge and Poppy, they're going to decide to start a country, and they split their country into 2 districts. And they equally split the legislature in the state. And for the moment, both of the dogs are pretty happy. So another dog is going to move into Smudge's district, and another dog is going to move into Poppy's district. And there are now 2 voters in each of the districts, which are going to be split into 2. And the district lines are drawn so that when those 4 dogs vote for their favorite colors, the colors are going to tie. So the 4 dogs are going to compromise, and they're going to be mostly happy with the outcome. Then, get this, 2 more dogs are going to move into the country, and we are going to have 3 districts of 2 dogs each. The district lines are still drawn so that there are 2 dogs per district. So the majority of the dogs are going to be happy with the result, which is going to give them representation that is proportional to the population in the country. Then something really exciting is going to happen. Smudge, she's going to run for president. And guess what? She wins. All right, so now Smudge gets to draw the districts, and there are going to be 3 dogs in each district. So even though Smudge only maintains 4 out of the 9 total votes in the country, or a minority of the vote for her favorite color, blue, she can draw the districts so that a majority of the seats in the legislature favor the color blue. So in a country of 3 districts of 3 voters each, she can maintain 2/3 of the seats in the legislature. And even when the country returns to 50% in favor of blue and 50% in favor of red, Smudge can still design districts of 3 voters each to ensure that she has a vast majority of the seats in the legislature, So in a country with 4 districts of 3 voters each, smudge can win 75% of the seats in the legislature. As a result, smudge has the ability to design districts that favor her chosen color of blue when she is in power, and perhaps for a very long time after she leaves office. And this power of smudge is directly related to a question that's currently in front of the Supreme Court. To what extent can those in power draw district maps that favor their chosen party? So the Supreme Court heard arguments in Gill versus Whitford early in their 2017 term. And this case concerns Wisconsin's 2011 redistricting plan, which was drafted by Republican legislators who held the majority in the state assembly. The map makers drew districts that were statistically likely to ensure a Republican majority in the coming elections. So in 2012, Republicans won 60.6% of the seats in the state assembly, with just 48.6% of the vote. In 2014, they secured 63.6% of the seats, with 52% of the vote. So the question for the Supreme Court is, does Wisconsin's map discriminate against Democratic voters? In other words, does this map create an imbalance in which a Republican voter's vote has more weight than a Democratic voter's vote? In particular, Whitford is arguing that the voting map uses tactics of packing and cracking. So now that we're this far along in the example, I'm going to show you a little bit more of a complicated strategy of drawing these districts. So in this situation, red has 40% of the votes in the state, and blue has 60% of the votes. But through this strategy of packing and cracking, you can eliminate the effect of the 60%. So packing would mean putting a large number of Democratic votes into a smaller number of districts. And cracking is going to be sort of separating the remainder of the Democratic voters into Republican majority districts so that they dilute the effect of the Democrats in those places. So even though the Republicans have fewer total votes, they can still secure a majority of the seats. What the court's going to have to decide is whether the way the districts were redrawn consistently provides Republicans with an unfair advantage over Democrats until the next redrawing of the map. So the challenge for Whitford is going to be to demonstrate that that advantage, measured by what is called the efficiency gap, is significant enough to judge Wisconsin Republicans' efforts as unconstitutional partisan gerrymandering, or that this partisan manipulation of district boundaries violates principles of equal protection under the 14th Amendment. So in a lower federal court, 2 out of 3 judges on a panel agreed that Wisconsin needed to redraw the map in order to shrink that gap, that fewer Democratic votes should be wasted as compared to the Republican votes in order to ensure that the districts were more competitive. By taking the case, the Supreme Court has put remapping efforts on hold in Wisconsin, and 12 other states, led by Texas, have filed a memo with the Supreme Court in favor of Wisconsin's position. So they are also not open to this idea that partisan redistricting could be struck down as unconstitutional. So an important swing justice, Anthony Kennedy, he signaled in the past that he's open to being convinced that partisan gerrymandering is an unconstitutional practice, even though the court has never struck down a redistricting plan on partisan grounds before. The court has struck down redistricting plans that target racial or ethnic groups, but this is a land that the Supreme Court has yet to sort of cross into. So some are worried that a decision in favor of those who would like to see more competitive districts would involve the courts too heavily in what is thought to be the job of elected officials, while others are worried that creating non-competitive districts with wasted votes is going to disincentivize voters from participating in an important democratic process. And I think there are some very important consequences of both of these worries. On one hand, if judges become the referee between parties in their struggle to design legislative districts, judges could face increasing threats to their independence. So in Pennsylvania, for example, the state high court called for a remapping of legislative districts in the face of partisan gerrymandering. And Republican politicians in Pennsylvania have called for the impeachment or the removal from office of those judges. And some states have implemented plans that keep both judges and parties, in theory, out of redistricting. So for example, in California, California has a 14-member citizen redistricting commission. And it consists of 5 Republicans, 5 Democrats, and 4 mystery party members. And a majority of each of these groups is needed to sign off on a redistricting plan. And Ohio is actually in the process of implementing a similar plan. And don't worry, Arnold Schwarzenegger brought the schnapps to celebrate. But on the other hand, without an answer from the Supreme Court in favor of Whitford's position, both parties may continue to design districts that consistently favor one party over the other. This may lead to a situation where legislators choose their voters and not the other way around. And according to best estimates, 10.6% more people live in the United States in 2020 than were counted in the 2010 census. Not only that, states' populations are shuffling around the country, and these patterns are going to affect the 2022 redistricting as states have to accommodate gains and losses of citizens in their remapping decisions. Right now, there is no decision on the constitutionality of drawing districts that consistently favor one party over the other. And I want to ask you, would you prefer to choose your legislators or allow them to choose you? Thank you.